everybody. Hope everybody's okay. We understand we've got a full house today, so that's great, and we've got a number of people entering the room as we speak. So welcome everybody for the BCS Law SG webinar. Delighted to say that I've got a colleague of mine, Josie Welland, who is going to be the speaker today. She is an expert in cyber security and cyber crimes. And yeah, she is a senior associate in the technology team at CMS. She helps clients investigate and enforce a wide variety of cybercrime, fraud, and other digital assets to clients and their customers. Prior to CMS, Josie specialised in representing clients in investigations and prosecutions brought by agencies such as the UK Serious Fraud Office and HMH Revenue and Customs. She's also got experience in matters concerning crypto and digital assets, and she's been involved in a number of leading civil crypto fraud and asset recovery cases before the English High Court. And outside of work, I don't know how she finds time outside work, but she does. She's also the chair of the Female Fraud Foundation. So Josie, welcome, and thank you for agreeing to present. Just in terms of housekeeping, if you could sort of put your questions in the chat, and then at the end of the presentation, Panagiotta, who is the BCS Law SG Secretary, will read out those questions and Josie will answer those. But yeah, feel free to put the questions in the chat and we will sort of collate them, and Josie will answer them at the end. So without further ado, Josie, over to you.
Thank you very much. Hopefully you can all see my screen. Can everyone see that?
Yes.
Yeah, I can see that. Yeah, that's great.
So this is a profile about me. We've done that, so we can skip right through. So what am I going to be talking to you about today? This is my agenda. I will try and keep us to 45 minutes, but I do apologise if I go over. There's quite a lot to cover today. There'll be some sections that I go into a bit more granular detail, but generally it's going to be pretty high level for today. And then if you have any particular questions, you can save them for the end. So for the first part of this webinar, I'm going to talk through, well, what do I mean when I say cybercrime? I'm then going to look at the legal framework from an English and Wales perspective. I'm then going to talk through some investigation techniques and considerations. And in particular, I'm going to tailor that at IT professionals, given the audience that I have today. I'm then going to look at computer evidence and expert evidence in a criminal context and how lawyers and IT experts, we work together in that space. And then finally, if we have time, I'm just going to give you some headlines of some of the enforcement actions that have happened in the cyberspace, either whether CMS has been involved in, I've been involved in, or whether it's just happening across the globe. So, sorry, my slides are a little bit slow. So what do I mean when I talk about cybercrime? So there's no universal definition, quite frustratingly, despite clearly it being universally accepted that cybercrime exists. The term cybercrime is used interchangeably with a lot of other terms. So just some of them I've put up there. So we've got computer crime, cloud crime, internet crime, computer misuse. They're all used interchangeably, but effectively mean the same thing. And that is internet or computer related criminal activity. Now, cybercrime in the context of England and Wales generally refers to criminal activity that occurs in the digital realm. So it encompasses quite a wide range of offences committed using computers, networks, or the internet. Now, to me, what is clear that to reference internet crime or cybercrime probably oversimplifies the legal wrongs, but also the potential remedies that are out there. To better understand the nature of crime over the internet or a computer, you need to really look at the distinguishing features. So in my opinion, there's really two main types. You've got cyber-enabled and then cyber-dependent. So what do I mean by that? So cyber-enabled is crimes is where technology helps to facilitate or enhance a crime that already exists. So a really good example of that might be theft, where in the olden days, if you were going to rob a bank, for example, you'd have to physically go to that bank. You might have to be armed with a firearm and you might have to hold some people hostages and go and steal the money from the safes downstairs. Nowadays, theft is more commonly committed online and with somewhat greater ease than having to go to a bank, getting the firearms, holding hostage and not getting yourself arrested in the process. So in that situation, and actually statistically, most crimes, when we talk about cyber crimes, are these cyber-enabled crimes. We then have the cyber-dependent crimes. So those are crimes which are committed solely through the use of technology. So where the devices are both the tool for committing the crime as well as the target of the crime. So examples of that are email spamming, copyright piracy, and basically anything that utilizes the internet or the computers or a software in order to commit an offense. So there's a whole wealth of cybercrimes out there. And I think most typically people think of a hacking attack followed by a ransomware. But in reality, and as I've put on the screen, there are so many out there. And what I've called out here is just the top 9, in my opinion, but there are so many more that I could have included in this list. I'm going to just talk through some of them and how they differ. And then I'll look at why cybercrime has increased and why it's so important. So you have the typical offense number 1, which is the hacking. So really, when I talk about hacking, what I mean is an unauthorized access to a computer system or a network. And what I've done there is I've just determined whether it's cyber dependent or cyber enabled. The next case scenario we have here is a phishing. So those are the deceptive emails that you get. So more often than not, you'll get an email pretending to be from a particular brand or from a friend. And then within that, you might either be deceived into think you're communicating with that genuine person, or more likely than not, they include some sort of malware, Trojan or virus, so that when you click on that link, what happens is that it then infiltrates your whole system. We then have identity theft. So this is coming far more prevalent as more and more of our data is online. And in effect, it's what it says. It's when you access someone's information, whether it's financial or otherwise, and then you use it for another purpose. Now, that could be anything. As it actually happens, there is no offence of identity theft, but it's often used as a basis to then commit other offences. But it's not a reportable crime. So if you were to report identity theft to Action Fraud, which is the kind of main database for cybercrime and fraud in the UK, along with the National Crime Agency, they would come back and say that doesn't form one of their reporting crimes. We then have online fraud. I'm sure you all know quite a bit about that, but it's fraud that's committed online. So it's financial transactions or false representations that are made through an online platform in some degree or in the digital world. We then have the more, I'd say, kind of modern type of offending that we're seeing more and more. So that's cyberbullying. So this is harassment or intimidation online. And actually, in more recent years, the government has taken quite a lot of steps to tackle that. And I'll talk through when I'm going through the legal framework, just some of the newest legislation that's only been in existence for a couple of months. We then have your typical data breaches. So this is where I was saying, when you think about cybercrime, these tends to be what people think about. So that's where somebody infiltrates your systems, they steal all your data, and then they demand payment in order to get the decryption tool in order for you to then access your data. We then have intellectual property theft. So this is where a company's brand is misused in some way. So a typical example, piracy. So if you've got the Premier League, for example, their brands will be used and misused. You also have others, so domain names, for example, are caught by that. And it's any sort of intellectual property that happens in the digital world that is misappropriated. And the last one, I think, is one that's probably overlooked, but actually probably one of the most common, and that's just the illegal selling of goods on online services or through the digital realm. So those of you might know the dark web. It's a fantastic, or maybe not quite the right word, an interesting place where you can pretty much buy anything you want, such as illegal drugs, counterfeit products, and goodness knows what else. But actually, a lot of this activity also happens on perfectly legitimate e-commerce websites as well. And it's because, in effect, cyber criminals are becoming far more brazen. So these are just some of the examples of cybercrime. And so when I am getting involved as a lawyer or I'm working with IT professionals, these are just some of the instances that we would be looking to investigate. And I suppose it's a question about, well, why are you even bothering? And the reason for that is because there is such a marked increase in cybercrime across the whole of offending in the UK. So what I've pulled here is some statistics from the National Office of Statistics. Now, they don't collect data just on cybercrime. What they do is collect data on computer misuse, and then they ask for the person reporting in whether or not that's reported online. So that's how we have these statistics here. As you can see, we have data up to the year end 2022. So we haven't got last year's data on these slides. It is available, but it's not on my slides today. And what I wanted you to see is the steep increase in the arrows or the straight lines in the graph to the right. So what you can see is that things were almost on a decline up to the year ending March 2019. We then have a break when COVID hit, as you can see. But then we have a huge uptick. So we have an 89% increase in the crime survey from March 2020 to March 2022 for Computer Misuse Act instances. And we have a similar increase for hacking. So what it shows is that where COVID forced, I think, society further ahead in technology and the use of technology in everyday life, what's come with that is reality that offending as we knew it has also moved on to the digital world. And so that, I think, accounts for quite a lot of the increase. But that's why in this day and age, cybercrime is so important, because it's really the new way of committing almost every offence that previously existed. Now, what I've just brought up here is just showing you how cybercrime impacts the different industries. And so all of these are industries that were approached and had to comment on the types of offending that impacts them. So here they were talking about fraud in particular, and then they define whether it's cybercrime or some other type. And what you can see is that cybercrime hits across every single industry that is pointed here. The lowest figure we have is at 27% for retail and consumer. And the highest we have is for the technology, media, and telecommunications. But really, the reality is that it represents at minimum just less than a third of all fraud, and as much as 50% for the industry. So it is having such a huge impact. So to be knowledgeable in the area, but also to be astute to what you need to do in an investigation for cybercrime, I think is really paramount. So in order for us to do that, I suppose we need to understand the legal framework. So what I have on my screen here is just 5 of some of the legislation that exists in the UK. Now, as my introduction suggests, and as the slide shows, annoyingly in England and Wales, there's no single corpus of cybercrime law. Instead, cybercrime is regulated by a patchwork of statutes and common law. Now, I've picked out just the top 5, and I'll go through some of these in detail. Some of them I will kind of rush through, but it means that from a lawyer, it's an absolute minefield, but also for the IT professionals or anyone that I'm advising, it's also a minefield, because I don't have one standalone statute or one standalone case law that I can go to and say, these are the cybercrime laws, these are the regulations, these are what you can and can't do. It just doesn't exist. And I think in part that probably reflects the reality of technology as a whole. So technology evolves and is constantly evolving. And so what happens is, as we advance in our use of technology and as we change it, the way we use it and what it does, legislation has to evolve with that. So what you can see here, the oldest act we have is the Computer Misuse Act of 1990, so some 34 years ago. And then we have the most recent act of only last year of the Online Safety Bill. So we really do have quite a range. But what you'll see is what each act tries to achieve does it slightly differently. So it is a bit of a minefield. And so unfortunately, my recommendation, not that I'm biased, is that you probably do always need to consult a lawyer. So rather than boring you with these weird icons, what I think I'll do, I'm going to talk you through just some of the most important acts. So I think for me and for you in this space, and when we're talking about cybercrime, really, the most important is the Computer Misuse Act. So this is the oldest form of legislation. And as the slide suggests, it's the most significant piece of legislation. And that's because really what it seeks to do is criminalise unauthorised access to computer systems, as well as the creation and distribution of malicious software. Now, there are 4 statutory types of computer misuse, or statutory type offences in the Computer Misuse Act. The first one is just simply unauthorised access or hacking. So this is where a person without authority physically, or more likely electronically, penetrates a computer system. And this probably can be compared to breaking and entering. So where you break an entry, but then you don't actually commit any further offence. You then got the step up from that. So that's the second type of offence you have. So that's when a person has unauthorised access to a computer, but does so with the intent of committing a further offence. So more often than not, that is the offence that you see. You have an unauthorised access followed by an intention to commit an offence. So a scenario might be theft or fraud. You want to defraud somebody, you want to steal their money, so you access the software, or you might want to steal their data. You then have where a person does an unauthorised act in relation to a computer, but they do so intending for that computer to become impaired or inaccessible in some way. So that's really when we're looking at the kind of more typical cyber instances. So where somebody deliberately creates a malware of some description that means that you can't access it. So a computer virus is a really good illustration of that. Then the final one under Computer Misuse Act is the one that concerns the making or supplying of articles for use in any of the above offences, really. So that's aimed at capturing those who knowingly facilitate computer misuse. And this can, I think, actually, of all the offences, probably causes the most concern for IT professionals, in my opinion. And that's because you often are in a situation where it potentially captures the dual use tools. So those that are there to test or highlight the security flaws. Now, in line with that kind of thought process, the government has for some time acknowledged that the Computer Misuse Act needs updating and changing. Now, in part, simply because it's 34 years old. Now, although computer isn't actually defined in the Act, and that's done deliberately because it doesn't want to be limited by developments in technology and evolution in technology, what it does admit is that it was drafted when computers, in essence, could only do certain things. So in 2021, the Home Office and the government indicated they were going to look at reforming that. And in 2023, so last year, the Home Office launched its consultation on possible amendments. And the response to that was published only in November. So I do encourage, it's not a particularly lengthy document, but it's quite helpful to see what the government proposed. So that was released only in November 2023. There were 4 key proposals that have come out from that. And one of those it comes to this statutory defence point. So there's an argument that a lot of professionals will inevitably either stray into activities that potentially fall foul of the Computer Misuse Act, or there's a concern that they will create a tool that falls foul to it. And so the government has taken that on board and understands that there is a need for that. And so they are contemplating putting together a statutory defence for protecting those in the United Kingdom who deliberately develop tools or carry out that activity for a legitimate purpose. So that's kind of one of the key changes. And that is actually mirrored on something similar to what they do in the US. But in the US, they have more of a policy document. So it's more of a discouragement of charging as opposed to a statutory defence. Some of the other key changes, which I think are quite crucial, one is just simply increasing the penalties. So as it happens, the sentences under the Computer Misuse Act are relatively low, despite the potential seriousness. And actually the Crown Prosecution Service guidance. So for those that don't know, the Crown Prosecution Service is the prosecutorial authority who will bring criminal sanctions against or on behalf of the state against individuals typically. And so in their guidance, they say that when a Computer Misuse Act offence is committed with a more serious offence, so typically you'll have the unauthorized access followed by the fraud or the blackmail or whatever it might be. Prosecutors are actually encouraged in their guidance to consider charging the more serious the offence because it attracts a higher sentence, and probably is easier, as you'll hear from me later, to prove. So I think with that in mind, they've realised that they need to up the punitive aspect of the legislation. They also, and I think is a kind of interesting conversation to have, is considering having a new offence of possessing illegally obtained data. So at the moment, there's, as I said, there's no offence for that. It doesn't really exist. So we have Data Protection Act and GDPR, which talk about how you handle data, and there are sanctions for that. But if you illegally obtain data, which isn't necessarily personal data, so it doesn't fall foul to GDPR, at the moment, there's nothing really that law enforcement authorities can do. So they're looking to see whether they can build out a new offence. And the final recommendation, which I think is, when you look at the responses, has had the most contention, is introducing new powers for law enforcement to require first the preservation of data, but then the ability to seize domains, internet protocol addresses for criminal purposes, or that are used for criminal purposes. Now, there's been some pushback on that, and I think I'm probably telling you all something that you already know, but preservation of digital data is an expensive exercise, in particular when you have to hold it for such long periods of time. Normally you have a retention period of 30 days, 6 months at most, sometimes a little bit longer than that, but generally you want to get rid of your data, and there's lots of reasons for that. So if there are new laws come in that allow for the extension of the preservation of that data, there's going to be a cost aspect to that. So actually what you see in the consultation responses is that there is a huge pushback on that provision, or at least saying that the government has to take into consideration the cost aspect. So they've acknowledged that, and they said they're going to work with people in the industry to better understand and come up with a better solution. So one proposal that they've canvassed is having the ability for people to preserve, or companies to preserve, data for a period of time whilst they determine if it's actually going to be relevant for their investigation. And then once it is or is not relevant, they can then decide what to do with it. So if it's not relevant, they can then delete it at that point. So hopefully reducing the costs. So I spent quite a bit of time talking through the Computer Misuse Act. I think the key takeaways are it's the main legislation in the UK to criminally sanction cybercrime. It's definitely in need of reform, and the government does appear finally to be considering that, and they've got some options open. So the next act that I've got on screen is the Investigative Powers Act. I'm not really going to go through that in too much detail. It's really aimed at public authorities, and what it does is it helps to regulate what they do when it comes to collecting data or intercepting devices. But because it only applies to public authorities, I'm not really going to go through it, because I would imagine most of us on this call are from private practice. But it does exist, and it does set the parameters upon which public authorities and what they can and can't do in effect. GDPR, I think I've touched on already, but sorry, I've gone a bit too excited. That just obviously deals with people's personal data. And more often than not, when you have a cyber incident, what happens is that when there is a breach, and a breach of personal data, often companies will also have to report to the ICO, so the Information Commissioner's Office, to report on that. So that deals with that side. I think the last act I really want to pay some attention to is the Online Safety Act. So this has been in the making for a very long time. There's been a lot of back and forth, and what it's really aimed at is trying to make the environment online safer than it is now. Now, it's targeted or kind of labelled in the headlines as the Social Media Act. In reality, it has a slightly broader scope than that, but it is predominantly aimed at the kind of social networking organisations. Now, it was finally passed and received royal assent at the end of last year. So it's our newest piece of legislation. Some provisions came into force in January this year. We have a few more that are coming into force in April. but most of the provisions are realistically going to have to come into force via secondary legislation, and that's in the future. So what is it trying to seek to do? So it's created a number of new offences or cyber offences. And I'm just going to list 5 of them, but there are more. So the first one that it imposes a false communication offence. So this really is aimed at protecting individuals from any communications where the sender intends to cause harm by sending something knowingly false. So we've probably all heard the concerns about the false information that's online about the US elections, for example. So it's aimed at putting a stop to that. You then have, or false emails about I've got this item to sell, but it doesn't actually exist. It then has an offence for threatening communication. So that's aimed at trying to prevent harm, where it encourages grievous bodily harm or some sexual abuse in some way. And so it's trying to crack down on that sort of communication. We then have the flashing offence. And I'll talk about that in a second because we've had a legal first this week. We then have criminalising or assisting or encouraging self-harm. So again, it goes to kind of making the online realm safer. And then finally, we have I think our probably first criminal offence for deep fakes or AI. It's a very particular offence and it's aimed only at pornography at the moment. But I have no doubt that they might extend that deep fakes to other criminality at some point. Now, I gave you a little teaser about our legal first. So just going back to the cyber flashing, we had the first conviction and first sentence is somebody that was convicted of that at Southend Crown Court this week. So the individual was convicted of cyber flashing, which for those that don't know is where somebody's intimate parts are shared via a picture image and it's unwarranted. So in that scenario, they were convicted and that particular individual actually received 60 weeks custody. And there was quite a lot of press around it if you're interested in the cyber world. And what's clear is that the authorities are going to look to penalise and sanction more and more people. So I have a feeling that my practice is going to expand somewhat, looking at potential offences of Online Safety Act. And actually those criminal offences are aimed both at the providers as well as the individuals. So in this particular scenario, it was an individual, but there are other offences or sanctions that can be imposed to those that allow it on their platforms. I'm not going to go through the Fraud Act. I think it's pretty self-explanatory, but naturally, more often than not, we talk about cybercrime, we also talk about digital fraud. So it's just when fraud has happened online, and we all bank online now, we all pay by our phones. So inevitably, if any money is taken from us, it's not the physical cash from our pockets, it's taken in some online or digital cyber way. So regardless of the kind of technical approach that was used, more often than not, what you find is that you're actually investigating under or bringing proceedings or looking at it from a Fraud Act perspective in line with the prosecution's guidance as opposed to computer misuse, because it's just, as I'll touch on, more complicated. So what investigation techniques do I think you need to consider? So I've just listed on your screen here and some. So these are, when I'm kind of dealing with a cyber investigation, these are kind of typically some of the things that I look at. And I think as IT professionals or in the space, these are probably what you're going to see. So I'm going to talk through them in a little bit more detail. So the first one I think is probably the most obvious is just the standard digital forensics. So that is obviously the collection and analysing of digital evidence from devices, networks and servers. You then have the preservation of data, which goes to the integrity and maintaining the chain of custody. And then you obviously also have to be able to be well versed in the tools that are used to assist with that. So data recovery, memory analysis and file system examination. And so I spend probably most of my, or a lot of my practice working with digital forensics. And that's before we even get to analysing, that's just making sure that we have all the data, that is safely retained, that it's not been intercepted with, which then allows us to then do some of the analysis further on. Another thing which I think is quite crucial in some of the practice that I do, but it's not always something that people talk about, and then that is network traffic analysis. It's something that in my practice we do quite a lot. So the traffic analysis effectively looks for anomalies, patterns, or unauthorized access in some ways, and I've listed there some of the tools that you might use for it. I think I'll try and give you an example of when we utilize it. So quite often I work with clients when there's been brand impersonation. So there's been a domain created using a domain that's very similar to theirs. And so often the question is, well, does that actually interact with our platform, or does it actually interact with our domain? And so we look at the network traffic to see if that is the case. Is it just completely dubious domain that's set up, has no interactions, or does it actually redirect or interact with the actual domain belonging to my client? The other thing that we also do is look for patterns. So can we see where else it connects? Does it mean that we are able to kind of broaden out the scope of what the perpetrators might be involved in? So it's quite a useful tool. I obviously, when I see it raw, I obviously need it to be translated even for my benefit. So I work with the IT professionals to tell me what it illustrates. Another quite obvious example is the malware analysis. So when you're looking at the kind of typical, what I describe as the typical cyber instances, there's going to be malware. So first we're going to be able to have to investigate it, but then you're also more likely not going to need to reverse engineer it. So you're going to need to understand, how did it work? What was the impact? Where does it touch? Where do I need to plug those gaps? So quite a lot of the advice that we often give in an investigation is not only to law enforcement or in our own enforcement action that we take about the wrongdoing, it's also feeding back to our companies and saying that this is the pitfall, this is where they were able to infiltrate. And so it's doing that analysis and saying that this was the gap that needs to be filled in order to stop it reoccurring. The point 4 is log analysis, and I'm just going to use what's been in the headlines this week. So it's the Kate Middleton, unfortunately. And I don't like necessarily bring in the royal family to conversations, but I think it's relevant. So for those that don't know, or those that do, I'll just elaborate a little bit more. So there's been a lot of conversation today across the press about this unlawful or unauthorized access of Kate Middleton's medical records. Now, the reality is, how have they been able to assess that? That's because they've looked at the data logs. So what they've done is that they have looked to see what employees or have been able or attempted to access Kate Middleton's medical records. They've probably then looked to see who is actually assigned to her care, and then determined that some of them aren't. And so log analysis, I think, is really important for determining things like that. And obviously there's now an investigation that's taking place. But it's also really important when you're looking at insider activity. So a lot of the time, if there's an apparent insider helping criminals in some way, the log instances will be able to best illustrate what they've accessed, when they've accessed it, what have they potentially downloaded, when have they downloaded it, does that then tally up with other data that you have? So a lot of the internal investigation work that I do when we're dealing with an insider will be looking at the log analysis. I've got a couple of other points there. I don't think I really need to go through with them too much. The only one that I really want to stress is the collaboration point and information sharing, which sort of goes hand in hand with the legal and regulatory compliance. So more often than not, what happens is you'll have a specialist team or a particular number of individuals that are assigned to deal with cybercrime instances, or to investigate them, or to do the reverse engineering. But what happens is that then there's that breakdown. So you have a tight-knit group of people that deal with this information, but then it doesn't necessarily feed either into the wider aspects of your company, or we then have to take that information and translate it so that law enforcement or lawyers like myself or the court understand what it means. So I think collaborating together and information sharing is super important. It's super important for kind of a wealth of reasons. One, it helps to educate you, and if you're working for the parent company, but then you have subsidiaries elsewhere, making sure that they're all aligned and they understand what's happening and they can see the fact pattern so that they know to stop in its tracks. It's also so that there's enough, for me as a lawyer, when I'm investigating, I'm sure that I have all the pieces of information that I need in order to then take the next step. And I think that's often somewhat overlooked. And sometimes it then necessitates there being a smaller group of people that needs to be in the know. But there's also a benefit in sharing some of that information. And so, I mean, hopefully what this slide illustrates to all of you is that cybercrime investigations really require a multidisciplinary approach, and they combine, technical expertise, legal knowledge, IT expert, everything. And so it's not just one person that can lead it all. So that's just, for me, kind of some of the investigation techniques that I think I come across most often in my practice. What I'm hoping to do now for the remainder of my talk is go through what is computer evidence and what is expert evidence. Now, computer evidence, I'm talking about it from the prospect of a criminal proceedings because we're talking about cybercrime, but actually this common law presumption that you see on the screen is applicable to both civil and criminal proceedings. What I want to do is just elaborate a little bit more on when I talk about what the significance of the change, so what the law was, and then what it is now, and then I'm going to talk you through why I think it's quite problematic. So to give a little bit of context, back in the 1980s, when computers began to become more commonplace, and it was necessary to consider, well, the courts took it upon themselves to decide that they needed to decide how electronic evidence could be presented in criminal proceedings. And that's because technically computer evidence, so data that's pulled from a computer, is hearsay evidence. It's second-hand evidence. So the person that is adducing it can't attest to it because they actually haven't produced that document. They've just taken it from a computer. Now, the rule then, and actually the rule now for hearsay in criminal proceedings at least, is that it's largely inadmissible unless it falls into one of the exceptions. And actually, at the time in the 80s, computer evidence didn't really fall neatly into any of those exceptions. So what happened was that the Police and Criminal Evidence Act 1984, which we all now know as PACE, introduced Section 69. And effectively what Section 69 did was require proof that the computer was operating properly. So you would have the data that was produced from it. You would then have proof that that computer was operating properly. And if you had both of those, then you could rely upon that data. Now, there was a lot of criticism based on that because as the volumes of computer evidence increased, this requirement became quite burdensome and rather inconvenient. Every time you wanted to rely upon computer evidence in some degree, you had to have proof that it was working properly. And it was a really onerous task. So the Law Commission back in the 90s, so it was 1995, proposed repealing that particular section within PACE. That was echoed again in 1997. And so in the year 2000, Section 69 was actually repealed. So where does that leave us now? So it was repealed without replacement. And so what we have now is a common law presumption. And the common law presumption effectively is that a computer is deemed, and the records that come from that, it's deemed to be working properly at all material times. And so therefore the record that come from that computer is fully admissible unless there is evidence to the contrary. So in effect, that means that a computer will be treated as always working properly unless somebody can show that that's not the case. Now, I think there's lots of problems with that. I think the first problem with this presumption is that, and actually the Law Commission, as I put here, really touched upon that, is how can you, as the other side, really effectively challenge a computer not working properly or presumed to be working properly if you have no understanding of how the machine works? So what I've put here is a quote actually from their own assessment. So it's from the reform of hearsay, and in my view, that's really quite an insurmountable problem. So you're faced with a scenario where you may think that a record from another device is potentially flawed, but you have no visibility on why that computer is flawed, because obviously it's not something that you've seen. From my perspective, I'm on the other side, so I don't have any visibility on how that device works. And similarly, if you're an IT professional, you don't understand the intricacies of how that particular device or computer works. So then how can you realistically then say, well, I don't think it's working properly? Because you've got no reason to back that up, nothing to substantiate that. So I think that's really a huge flaw. And I think actually it puts people in quite an unfair advantage. And, unfortunately, the courts are also not particularly sympathetic. So when you do, in criminal cases, challenge the credibility or integrity of computer evidence, more often than not, unless you have some substantive reason for that or some evidence to support that contention, any application to the courts to get more information about the device or to kind of press that point are just wholly rejected. Now, I don't need to tell you, but a really prime example of that is the Horizon scandal that's been all over the news since the ITV documentary. And there's a lot of argument about the fairness of those prosecutions, but in reality, the law allowed for that to happen because there was this automatic presumption that a computer was working properly. And unfortunately, the defendants in that case, the postmasters, didn't have the ability to challenge because they didn't have visibility on the failings of that computer system. So that's a kind of a real world example of it. But I think looking at it from a more technical point of view is that a computer isn't infallible at all. And I think if we're looking at it from, with anyone that has a level of expertise in computer science or software engineering, in order to say that a computer is working properly, that requires a binary yes or no answer, and also correctly, or I would say incorrectly, assumes that is trivially easily answered, and it just isn't. Computers are far more complex. All computers have propensity to fail. They all have bugs, errors, defects, and some of them may rarely reveal themselves. You may not even know that they're there in any particularly obvious and noticeable way, or they may even masquerade themselves as normal behavior. So it's not really that straightforward to say whether something operates properly anyway. But in any event, the other problem is that even if a computer isn't working properly, if we're going to answer it in a binary yes or no answer, it doesn't necessarily then mean that the record that's been produced has been impacted by that bug, error or defect. And so I just really think that we have a really problematic situation at the moment where we have this presumption that there's a reliability on the evidence that it's always correct, but actually that's just not how computers work. And I think the government needs to really consider how they can make changes. I think something else that I wanted to touch upon, which so we've got the issue about the common law presumption, and I think it is a really troubling issue. But there's also other kind of more legal problems that we have when it comes to proving cybercrime. And again, it goes to really the technical aspects of when you're dealing with a computer. So continuity of evidence, and I referred to it earlier as a chain of custody, is quite a problematic area for when you're looking to enforce against cybercrime. And the reason for that, and I'm going to take the example of hacking because I think it's quite an easy one, but really only in the most simple of cases will you have two computers, so the perpetrator's computer, the victim's computer, and then the identified bad actor. In reality, you're not going to have that. You're going to, the hacker's going to send commands across various different computers that are spread across all over the internet, and then they're also going to try and mask their identity. So you have the issue of fragmentation and spoofing. So just kind of delving into a little bit on the fragmentation point. As I'm sure most of you know, messages and commands sent over the internet or digitally do not pass between the sender and the receiver computer. Instead, the messages are broken down into smaller packets and each with a destination address. So each packet is kind of passed from computer to computer across the internet until eventually it gets to its end destination. And then eventually, once it arrives at its final resting computer, in a matter of seconds, I have to say, the message or whatever the command is will then happen. And that's the same with the hacker's message. So we have this really complex situation where, when you're looking at it from a cyber investigation point of view, we have to prove that the message has passed from all these different devices and then ended up at the victim's computer. And that's quite hard to achieve. So, as I see here, and I've highlighted in blue, we have to demonstrate the hacker's message or the command did travel to that unauthorized computer. Now, the courts have tried to, through case law, make that a little bit easier. So they now distinguish between the producing computer, as it were, and the transmitting. So when it's the producing computer, it's the one where they have produced the command or the message that then's passed through. We then have the transmitting computers. So my device right now could, in theory, be transmitting some hacking message or command somewhere, but I would be unknown. But if my device was ever then forensically examined, I could fall foul to offences under the Computer Misuse Act. So the court recognise that and have tried to make that life a bit easier. But it's a hard exercise. And as IT professionals, as lawyers, we have to overcome that problem. The other issue we have is spoofing, or, to put another way, the perpetrator's attempts at trying to hide their identity. So really unlikely you're going to have a hacker who logs into a computer using their own identity or an identifier. What they're going to do is try and mask that in some way. So they might do that by obtaining the login details for somebody else, or they might create a new identity, fooling that computer into thinking that they're the systems operator. Whatever the technical method they adopt, the legal result remains the same. You still have to show that. So even if you can illustrate that this computer was the one that sent the command, it passed through X, Y, and Z computer to get to the victim's computer, we then have the complication of proving that the perpetrator sat in the dock or subject to your enforcement action is actually the person that sent that command. Because all we actually have at that point is proof that the computer sent the command, not the person sitting behind it. So again, it sounds, when you think about it, it's really easy, but actually it's quite complicated. Or often than not with spoofing, what we tend to do is look to see if they make a mistake. It's, all they have to do is forget to put their VPN on once, or using the same email address that they used for a MySpace account like 20 years ago or something like that. And that's all we need to be able to put a face to an identity. But it takes quite a lot of skill and quite a lot of time. And we have to work with IT professionals and other investigators to kind of paint the picture. So my final kind of few slides, if I can get it to work, is expert evidence. And this really kind of goes to the crux of it all. So I may work in, or we all will at some point assist an investigation, and we'll go through all the processes I've gone through. But then what about when you're called upon to be an expert? So I'm talking about it from a criminal law perspective. And what I've put here is just, well, what is an expert? So it's ultimately a determination for the judge. You don't have to have a particular, qualification or particular, level of experience. What it says is either or. So you have to, have sufficient body of knowledge to be able to attest to something and for it to be reliable. But then also that it assists the court in a particular issue. So to take myself as an example, I can talk to cybercrime, I can talk to digital fraud. I could not talk to real estate. It's not my area, don't know anything about it. But people might think, oh, you're a lawyer, therefore you must know about real estate. I don't. Admissibility. So expert evidence is admissible under Part 19 of the Criminal Procedure Rules 2020. That sets out both the procedure for reducing it, and then we've also got the practice direction, which talks about what form your witness statement should take, or what the joint statement should take. I'm not going to bore you with the details of that. The only other admissibility point which I thought might be interesting to flag is that where I talked about earlier, the hearsay evidence point and the fact that computer evidence isn't always admissible, actually in expert evidence, sometimes your expert report can be admissible with leave of the court, even in the absence of you giving evidence orally. You still have to get permission from the court, but it is permitted. So it's quite rare. You're normally going to be cross-examined on anything you attest to, but there is that opportunity for it to go in without you having to be called to give evidence. Now, the final thing that I've put up on this side, and I think probably it's the most important, if any of you on this call are IT experts or ever called upon to be IT experts in any criminal case at any point, is the duty that you have as that expert. So as an expert, so that's any expert, in this case we'll talk about it from a computer expert, you have your overarching duty and overriding duty is to the court. So it's not to the person who instructs you, it's not to the person who's paying your fee, it is to that court. And that expert evidence has to be objective and your opinions have to be unbiased. So, and I understand that's a really tricky situation to be in, because when you're instructed by your firm or you're instructed by me, you want to be able to appease me and do what I'm instructing you to do, and hopefully, give me the outcome that I'm looking for. But that is not what your duty is. Your duty is to that court. And so the reality, if it means that you come back and you give me advice or you inform me of something that is unhelpful to my position, so be it. Now, there's also a specific duty when giving testimony in court to draw the court's attention to any question that falls outside of your area of expertise. And I actually want to talk through a case that's been referenced quite a lot around this. So this is a case of Pabin. It's a 2018 Court of Appeal case. It actually concerned the LIBOR rigging. Now, the reason why it's relevant is because in that particular scenario, the expert strayed way beyond his knowledge of banking when it came to asking questions. And what happened is that all came to light after the individual was convicted, and so he then sought to appeal his conviction. And what happened in that case is the court was absolutely scathing to the expert in that scenario and was really critical, because ultimately you have this duty as experts to identify when you can't answer a question. So same if I was asked a question about real estate, I wouldn't be able to answer it. I should say I don't know the answer to that, or that's not within my area of expertise. But this particular individual didn't do it, and what he did is formed opinion based on the undisclosed opinion of others. Now, actually, in that, it's a bit of a juxtaposition, I suppose, notwithstanding the fact that the court was very critical of that expert in that scenario, the conviction was actually upheld. And the reason for that is that the causal link between the conviction was a dishonesty. So although this guy was talking about banking, it didn't realm into straying off into what actually resulted in the conviction. And then I think my final slide, because I'm conscious of time, one interesting fact I think you should know before I sign off is just that there is the ability to withhold information. So there is a basis for you to withhold information on public interest grounds. So if you are somebody who is in the cyberspace and you're testing, I don't know, you're an ethical hacker, for example, or you utilize or circumvent an encryption tool in order to access something, there are provisions that allow for the courts to withhold that information. So the case that I'm talking about is a case called Kelly. And in that particular scenario, the expert had circumvented the encryption software on a drug dealer's mobile phone. The prosecution then resisted an application from the other side of what mechanisms were used. And that was on the basis, and I think quite a right one, that if that information was revealed, first of all, it potentially meant the expert could fall foul to offences under the Computer Misuse Act. But more troublingly was that court hearings are notoriously public for the most part. And so that information could fall into the hands of the criminal, and so then could be utilised again. So I think that's quite interesting thing to bear in mind. Some things will be kept secret. I'm going to put on the screen, but I won't talk through, are just a joint and single expert. So more often than not, you have to do a joint statement sometimes with another expert. And then I've just set out here when you challenge expert evidence, when that can happen and how it happens in criminal practice. But I'm conscious we're getting quite close to time. So I think I will turn over to questions if anyone has any.
Thank you very much, Josie, for this wonderful presentation. In the chat, there are a few questions. So one has to do with Graham Gee, and he asks, are there any examples of problems, legal dispute cases arising?
Sorry, Josie. Yeah, it's about the presumption. So I think the speaker was basically saying that the presumption's been around for a long time.
Yes.
And, has there been, apart from obviously, the post office thing and other ones there, I guess you could mention the Euro one, can't you? The Euro.
Yeah, so the EncroChat, I think is quite
EncroChat,
a
sorry,
example. So for those that may not know, so EncroChat it was effectively a messaging service that a lot of criminals used or allegedly used, and for ages law enforcement authorities couldn't gain access to the EncroChat material, and so they couldn't necessarily go to prove the criminal wrongdoing of the perpetrators. And a couple of years ago, French authorities in conjunction with Dutch authorities were able to infiltrate the EncroChat device, as it were, or software, and were able to then pull out some of the data. Now, the problem with that now is it's deemed to be fully admissible in the UK and across a lot of other countries as well. So what effectively they've done is, from infiltrating the EncroChat material, we now have a lot of criminal convictions in the UK that are derived from the material. So there'll be communications about drug deals and whatnot. Lots of defendants have tried to challenge that evidence, but they've never succeeded. So they've always been dismissed. And it's a lot to do with this presumption. And also, I think a little bit in part because in France in particular, where the infiltration apparently happened, there is secrecy around investigations. So the French authorities aren't going to reveal it because they don't have to. There's that security, kind of secrecy that sits behind it. But then we also have this presumption that it's always deemed to be right. And so you can't really test if it's right or wrong because you don't really know how they were able to achieve it in the first place. But then obviously outside of that, there is question mark about the fairness of that.
Another question from Alex Holland. Are there any statistics on prosecution and conviction rates for cybercrime in England and Wales?
So I could probably pull them up. I don't have them to hand. Like I said, unfortunately, in the same way that the Office of National Statistics don't capture cybercrime as a whole, they don't do that for prosecutorial outcomes either. But what we can probably try and do, and I can follow up if needs be, the percentages. So we probably have to look at convictions under various different offences and draw some conclusions.
Thank you. And then again, for the presumption, Phil B, maybe people don't contest the presumption because they consider it to be of no use, to be futile.
I think that's probably fair. I think there is that, I suppose, opinion taken perhaps by others. I don't agree. I think if you don't challenge it, you're never going to have the opportunity. I mean, it is a little bit subject to how resistant the court is, but I do think we're actually probably in a slightly different realm to where we were last year. I think since the post office scandal, we are now in a situation where the courts are probably going to be far more live to the possibility of data being flawed. So I certainly know from my own perspective that since this has all kind of come to light, and I mean, admittedly, it's been in the public domain for a while, but since the IT dramification of it, when I'm working with law enforcement, or I'm working with authorities across the globe, they are more and more pushing us to have other contemporaneous evidence which goes to support my client's data. So they're not taking the data in and of itself on face value anymore. They're looking for anything else that supports what the data also shows. And that's a bit of a tug of war, because, the data for your clients view often when they pull data, or as IT professionals, like, well, that's what our records show. So where's the question mark? Yeah, I think there's going to be a change, I think.
Thank you very much. There aren't any more questions in the chat. I don't know if any of our participants wish to address a question. In this case, please raise your hand and I will unmute you. If not, I would like to thank very much Josie Welland for her presentation and being with us today. I don't know if some wishes to our chair to say a goodbye. Tom, do you wish to take the floor?
No, thanks, Panagiotta. Thanks, Josie. I'm just looking through the comments and the questions, and the majority are comments saying great presentation. Thank you very much. So I think it was well received. So thank you. I think it's a complex area, and I think you've just demystified it quite well. So yeah, I think that was great. And and to the audience and attendees, thank you very much for attending on a, trying to think which day is it, Thursday, nearly the weekend, Thursday evening. It is Thursday, isn't it?
It is Thursday.
Yeah, it is, Thursday evening. So thank you very much. And also, this group is for you guys. So if you've got any ideas for topics you want, do send an email to the email address on the BCS Law SG website in terms of, I guess, what you want to learn about. And alternatively, if you think you've got something interesting you want to talk about, please do reach out and we'll be happy to host you. As I said, it's a group for you guys. So yeah, trying to make the most of it. So without taking up further of your evening, wish you all a good evening and have a good weekend. And yeah, we'll see you next time at the next event. So thank you very much. Bye.
Thanks, everyone.
Thank you. Bye. Thanks, Panagiotta. Bye.